Everyone, this is Tamara, your courtroom companion, and you'll notice I'm not in my typical surroundings. I'm actually out of town, and so I don't have my usual equipment with me, so I do apologize. The lighting is not as good as I normally would like to have, but just bear with me. I still wanted to shoot this video and get it uploaded for you. So today's video, titled, "If you do this, you'll likely lose custody," I'm going to share with you what that one thing is. I'm also going to share a couple examples of what I mean by that one thing. And stay tuned to the end, because I'm actually going to read to you from two different transcripts of two different hearings I had. And the portions I'm going to read you are actually from a judge, two different judges at two different times, when they were referencing my ex-husband when he just did this one particular behavior that I'm going to encourage you not to do. And so I'm going to share with you all of that in this video. And so before we get into that content, I do ask that you subscribe to the channel and hit that bell notification so that you'll know when I upload my content. And as always, what I share here is just my own experiences, my own opinions. I'm not a therapist, I'm not an attorney, so please do seek out that professional help if you do need that. These are just, my own journey, hoping that it will be helpful to you as you go to court. So let's jump right in. So what is that one thing? That one thing is valuing the fight with the other parent over what is in your child's best interest or your children's best interest. So what do I mean by that? Let's just give an example. So let's say that your ex asked if your children can attend a family reunion with him on a weekend that's typically your weekend. And you say no, just because you want to be ugly to the other parent or whatever. And I'm not saying if the other parent is dangerous in some way or you have safety concerns with your children. I'm not saying ignore those safety concerns. What I am saying is that you put your children's needs above your own in that moment. And while you might want to be ugly to the other parent just to get some satisfaction, your children may want to go to this reunion, and maybe you could suggest swapping weekends or something like that in order for them to go. That extended family may be very important to your children at some point, as they struggle to recognize what's going on with the narcissistic parent or something like that. And so this just gives them more people in their life that will love them. And again, I'm not saying if the other family is crazy in any way or dangerous in any way. I'm not saying send your children there and not be concerned about safety. I'm just saying that if at all possible, if your children want to go to this reunion, try to facilitate it, because that puts your kids' needs above your own need to get satisfaction against the other parent. Another example might be if your children want to attend a sporting event or want to be a part of a sports team that the other parent is coaching. Don't not allow them just because the other parent is coaching and somehow they're going to get more time with the children. It's not about that. It is about the children and what they would like to do. And this extra time with the parent, you might not like it, but in some ways that might be good for him or her to see their father interact in a different way with other children or something like that, or they just might get a benefit from being on a sports team that teaches them discipline and teamwork and those kinds of things. So that's what I mean by putting your children's needs above your own need to fight or to get revenge or be ugly to the other parent. And so now what I'm going to do is I'm actually going to share with you that verbiage from transcripts that actually is from my own court hearings and the judges that said things in our court hearings. So let me grab that. So this first transcript is from what we call a pendente lite hearing, where pendente lite is just a kind of a fancy legal term to mean temporary. So my ex lost temporary legal and physical custody with some limited physical access during this time, but this hearing was the one that decided that schedule. So this is from the prior part of this, the judge is explaining the factors that he used for assigning custody cases, how he used them. It's called the best interest factors. And he says, I could go through a number of these. You saw where I have a bunch of these marked, and he's talking about the exhibits. So in this particular hearing, I was not represented. I didn't have an attorney at the time. My ex was represented by an attorney. And so we both presented evidence at an all-day hearing. This lasted all day long. And based on that evidence, the judge changed our custody. He said there was a change in custody needed, and this is him reviewing the evidence during the final ruling. He says, I could go through a number of these. You saw where I have a bunch of these marked, and they are all different examples of that exact same thing. So what do? Do I put you back? One of the things, and he mentions the attorney's name for my ex, said is just to leave the schedule the way it is and shore up the holes. And I'd really like to do that, but we're 10 months away from the merits hearing, which is our final court hearing. And I'm not convinced that that will work. So what I have to really look at is what gives the best chance of all the factors in our county versus, and he cites a case that he often cited in our trial. Whenever we start hearing a case, I did family law as a lawyer for 35 years, tried many cases. And so I start immediately thinking of all those issues and having this case since early this morning. But the factor that has struck me the most during this is which party will give the other the best chance of having the other have a good relationship with, and he says our son's name. And what I have not been able to get out of my mind, because I found it so compelling, was last football season, because, and he mentions our son's name again, has football practice on Monday, Tuesday, and Thursday, and Wednesday he has church. So those are 4 huge blocks of time that Dad has had. Dad was the coach at the time. And that's not necessarily going to change. Yet Dad also expected, after having all that time, to have a phone call at night during what little time Mom had, and he testified to that. And I understand the court order said that, but it doesn't pass the common sense test, because he has already been with his son and has had opportunities to talk with him, and I know that he wants to pray, and I know that he wants to do Bible study. I know what the testimony was, and I'm not knocking that. That's important. But the most important thing is to lead by example, and I think a large percent of the time you do, but it's that small percentage that I don't. So he was basically saying that our son was on the football field with his dad as the coach 3 nights a week, and then he went to church with his dad on Wednesdays, and yet he still expected the nightly phone call that was allowed in our court order. But he didn't put our son's needs first, which was he had so little time at home. I would race home from work, get our son to football practice. He would be there for 3 hours with his dad, and then he had to still eat. He still had to do homework, take a shower, and maybe see me from time to time during that period. And yet his father still expected to have that nightly phone call, which would have taken even more time away from our son, which was not in his best interest. His best interest would have been served to do his homework, get good rest, and eat and shower and those kinds of things. So the judge, in my opinion, from those words, was saying that basically Dad was putting his own interest above his own, and he valued the fight over, what he valued was taking time away with our son from me, and that was his way of doing it. And he relied on the court order, which said the nightly phone call he was entitled to. But again, the judge said that doesn't pass common sense. So this is what another judge has said, and this was during our permanent custody hearing, where she was going to decide what our permanent custody schedule would be. And she's also reviewing the factors, the best interest factors. And she's at the one where it's the willingness of the parties to share custody. So that's one of the best interest factors. And she says, this is where we have a problem, and it's a significant problem. And I come into this case, and you're both on equal playing field. And what I've got to do, I've already made the determination you cannot work together, because it just does not work after considering all the evidence. And we had a 12-day trial. So she's weighed 12 days of trial, or 11 days of trial, and this is the 12th day where she's actually giving the ruling. And so then from there, I have to weigh which parent is most likely to not exclude the other parent, who to consider the other parent in making decisions to consider our son's needs to have a long-term healthy relationship with the parent who does not have custody of him. All of those things I have to consider to determine which one of you will end up with sole legal custody, and devise a physical custody schedule around that as well. In this regard, I find that Ms. Alexander, me, is more likely to support young, and she says our son's name, relationship with his father. She gives him time for extra special events. She offered him time for the NFL game, Winterfest, the college graduation, grandmother's birthday party, those types of things. While they do not like each other or trust each other at all, she does seem to be better able, through the evidence presented, to consider our son's name needs beyond her distrust or dislike for Mr. Alexander. Mr. Alexander appears less willing to share custody in any meaningful way. The evidence presented reflects repeated efforts to marginalize Mom, and I believe he allows his distrust for her to permeate every or nearly every discussion. She does not appear to respond in turn. So that's 2 different judges who have said that basically I am able to put my dislike, distrust for my ex aside and do what is in our son's best interest. And that's what I'm encouraging you to do. And if you're here watching these videos, you're probably the parent who is doing just that. So hopefully this video is encouraging you to continue, because sometimes it can feel like, why do I have to keep doing this? Or why nobody is recognizing your efforts to do this? Well, they eventually do get recognized. And you're not doing it for the recognition. You're doing it because it's your children's best it's in your children's best interest to continue to put their needs above the fight against your ex. But sometimes it can feel like you're losing, or it can feel like, maybe the ex doesn't respond in kind. Maybe you ask for time extra and he doesn't, return in kind. But I want to encourage you to keep doing it in spite of his behavior or her behavior. Keep doing the right thing. The judges will eventually see through that and be able to see which parent is putting their children's needs above everything else. So hopefully this is encouraging to you, and hopefully this video was helpful to you. Please do leave comments below if you have other experiences in this area. Our community would love to hear about it. I'm also going to link a video I did a while back on the 10 ways to lose a custody case. I think that's relevant here as well. So hopefully that video will be interesting to you. And as always, have a great day. I'll see you next time. Bye-bye.